My name is Stanley Kinyanjui. I'm an advocate of the High Court of Kenya, and I'm here to address an issue that we have seen in the media over the past few days that have caused an uprising amongst the youths, or what we commonly call as Gen Z of Kenya. Now, Albert Ojwang was found dead, I believe, at Central Police Station, and there has been some factors and effects that have followed since the discovery of his body. Now, the law is not so silent about what should happen, especially the procedure that should be taken once a dead person is found or is said to have been found in police custody. Now, when you move to the Criminal Procedure Code, Section 387 lays the substantive grounds and laws upon which an inquiry is sanctioned by either the magistrate who does so suo motu, or I can also say independently, or in conjunction with the investigations that are usually carried out by the police. But before we get to that part, I wish to remind us of the National Coroner Service Act. And this act has been brought into force, and it lays down procedures of when a dead body is said to be found in a police station or in the possession of the military. Now, the first step is that once a dead body is found or a deceased person is found, it is the duty of the officer commanding the station or the officer in charge of a prison who discovers a body or comes into information that a body has been found in their possession. Now, the Act mandates that once that is done, the officer in charge or the officer in commanding of that station should inform the coroner within the shortest time possible, and if not so possible, or practically impossible to do so within the shortest time possible, they should do so, and over and above that, also issue a letter indicating why they could not inform the coroner of such a death. Now, once that is done, it is the duty of the coroner to investigate the cause of death upon such a report having been made. Now, the details of that report should include the name of the deceased, how, when, and where he died. 3, the circumstances revolving his death. And 4, the investigation that the investigation that ensues, so that they can publicly give directions or declare the cause of death of that particular person. This also goes in tandem with the filling of the births and deaths registrations, acts and forms. Now, once that is done, if the coroner has information, having done the autopsy or post-mortem of the deceased person, creates an opinion that the death of that prisoner or that of their suspect in this case, then he has a duty to provide a report and give that report to two people, that is the DPP and the Inspector General of Police. After that, any other interested person, and now we go back to this case where we left it earlier on, this being a magistrate who has ordered an inquiry as to the deceased, then is also a party who has, or rather gets, the report of the coroner. Now, moving back to Section 387, we go back and start the inquiry process. As I had earlier on indicated, that an inquiry can either be done independently or together with the investigations of the police. Now, There is also an issue about jurisdiction. That is, it is always advisable, and this is the provisions of the Criminal Procedure Code, that where a deceased person is found, the police station or the prison where that person dies, the inquiry should be taken, or rather should be undertaken by the nearest magistrate within the local limits of that jurisdiction. Now, in this case, we can see that the deceased, Mr. Ojwang, died while in custody at Central Police Station. Then, therefore, that brings us to the Milimani Law Courts, or the Magistrate Court in Milimani Law Courts, to order the inquiry. Now, in the event that the body has been buried, then the law provides, or rather gives powers to the magistrate to order for an exhumation, and that once the exhumation is done, then a post-mortem to establish the cause of death can be done. Thereafter, once that is ascertained, or rather once the cause of death is ascertained, then the inquiry process, as it is ongoing, the magistrate has three options. One, he can summon the persons who are believed, or once the magistrate forms an opinion that there is a person culpable or linked to the death of the deceased person, at the beginning of the inquiry, the magistrate has the power to summon that suspect or issue warrants of arrest to that suspect. Or two, in the middle of the inquiry, it becomes apparent that a suspect has been identified, then the suspect can again be summoned or warrants of arrest issued. And the third is that summons or warrants of arrest can be issued once an inquiry has already been determined. But if it is so done that the summons or the warrants of arrests have been executed against any suspect, then the inquiry process starts de novo. When I say de novo, it means it starts afresh. Now, the reason why it starts afresh is because it gives the suspects the right to a fair hearing, where during that process, they are allowed to have legal counsel represent them so that they can cross-examine any evidence that is tabled or leveled against them. Now, once the inquiry process comes to an end, the magistrate again goes back to his notes and the proceedings thereto and ascertains and forms an opinion that either one, the suspects are culpable, or two, the suspects are not culpable. If the suspects are culpable, then he or she records that opinion and forwards the file to the DPP, and the DPP commences charges. If the latter is found, then the file is closed. That is the procedure.